Thank you so much, Ms. Wells. My clock only shows 12:59, so I will give everybody a few more seconds to log on here. All right, my clock shows 1 p.m. and I will call this meeting of the Senate Judiciary Committee to order on Wednesday, February 17th. Would the secretary please call the roll?
Thank you. Chair Scheibel.
Present.
Vice Chair Cannizzaro.
It looks like she's not here yet. I would ask that you please mark her present when she arrives. And as always, I will try to let you know when I see her come in.
Thank you. Senator Orenshaw.
Present.
Senator Harris.
Here.
Senator Settlemyre.
I can see Senator Settlemyre. It looks like his device is still on mute.
Okay. Senator
Here at
Hansen.
the historic Virginia City Courthouse. Sorry about that.
Senator Hansen.
Senator Hansen is here. I'm here.
Senator Pickard.
I am here.
Thank you.
All right, thank you. And we have 3 bills to hear today, but we are on a tight schedule. It's 1 p.m. now. We have until approximately 3 o'clock to hear 3 bills in 2 hours. So today I will be limiting testimony on each bill and each position to only 10 minutes in order to allow the committee ample time to ask questions of our presenters and the numerous subject matter experts that we have present with us today. I would encourage everybody who is here to testify to submit written comments. If you want to submit your testimony after the meeting or during the meeting, we can still accept it via writing. And I'm going to give you all the email address that you need to send it to. It is sen, S-E-N, Judd, J-U-D, at sen.state.nv.us. This can also be found on the agenda. And I'll also remind you that each testifier will be limited to 2 minutes per person. And you are always welcome to just say, ditto, I agree, my organization has the same position, something like that. The 2 minutes is a maximum, not a minimum. And when we are finished hearing the bills, we will use the remaining time left in our meeting for public comment. And I look forward to hearing from all of you, whether it be on the phone today or via writing or in the future. And with that, we have our esteemed Attorney General here joining us to present 3 bills. And we will start with SB 41. I believe that Mr. George and Ms. Haar will be assisting Attorney General Ford on those. And I will now open the hearing on SB 41.
Thank you, Madam Chair. I don't know if the Attorney General wants to do introductions before we get started, so I will give him a minute to see if he wants to respond.
Good morning, Madam Chair, members of the committee. I am Aaron Ford, your Attorney General. It's so great to see you all. I'm sitting here in Carson with my second assistant, Christine Jones-Brady. I'm in my mask, but we're 6 feet apart. I'm going to take it off so that I can talk and you can hear me better, but I wanted to start it off in the right way. Thank you again for entertaining us today. Frankly, it's fantastic to see you all in your smiling faces. I fondly recall my days in the state Senate and fondly recall serving with so many of you. And so it's great to see you there. I will not say more before you begin on SB 41 and instead tender the microphone to my colleagues in the South, Kyle George and Teresa Hart, to present this bill. Thank you so much.
Good afternoon, Chair Scheibel and members of the committee.
For the record, my name is Teresa Haar, and I'm the Special Assistant Attorney General here at the Attorney General's office. I'm joined by Jessica Adair, our Chief of Staff, Kyle George, our First Assistant, and William Scott, our Chief of Investigations. I'm providing testimony today in support of SB 41. Under existing law, under NRS 179.530, the District Court has the jurisdiction to issue orders authorizing the use of PIN registers and trap and trace devices. And by way of background, for example, a PIN register identifies all outgoing phone numbers dialed by a telephone, and a trap and trace device identifies all phone numbers dialed incoming to a telephone. The contents of these phone calls or communications are not recorded in a PIN register or a trap and trace device. This proposed bill makes a few changes to the mechanics of the application, but does not make any changes to the contents of the application. Currently, the District Court issues the order upon application by a member of a District Attorney's Office or the Office of the Attorney General, and it's based on an affidavit from a peace officer. Currently defined in statute, a peace officer who can submit a supporting affidavit is limited to sheriffs and their deputies, DPS personnel, peace officers of cities and towns, Gaming Control Board agents, Attorney General Office investigators, District Attorney Office investigators, and the Office of the Inspector General for the Department of Corrections. This proposed bill seeks to include in the definition of peace officer, federal officers who are members of a task force with state and local law enforcement officers. This proposed bill also seeks to bring the mechanism for submitting an affidavit and the application into the modern world. And especially as we've seen in the past year with COVID and physical access to courthouses being limited, we found it especially important to allow for electronic submission of the application and the supporting affidavit. Under current law, there is no specification as to whether electronic submission is permissible, and it really varies from court to court. And this will make for a consistent process statewide. Lastly, this proposed bill eliminates the date specified for the federal statute that is incorporated by reference, especially since the federal statute has since been updated. And I want to thank the committee for their time for entertaining this bill, and we welcome any and all questions from the committee.
All right, thank you for your presentation. At this time, I will open it up for questions from members of the committee. Again, if you could use the raise hand feature on our meeting, that would be great. And if you can't, I'll still call on you. Are there really no? Okay, Senator Harris.
Thank you, Chair Scheibel. I'd just like to know a little bit more about what the requirements are in federal law. I know you guys reference it in the bill. And if you could just follow up on also why we deleted the as passed in 1989 or whatever the language is.
Thank you, Teresa Haar for the record. So under 18 USC Chapter 206, the requirement for obtaining a PIN register or trap and trace device is very low. It is a certification by an applicant that the information likely to be obtained is relevant to an ongoing criminal investigation. This is a very low burden. However, dating back to 1979, the U.S. Supreme Court held that no person has a reasonable expectation of privacy in the phone numbers that you dial. And that is because it's not actually your personal information, but instead is information that you are relaying to a utility company for them to complete your transaction. And so it is a very low burden and it's a very low application standard, but the information being obtained is not anyone's personal information that would require probable cause like under a warrant.
Date.
Oh, yes, and regarding the date, certain provisions of Chapter 206 under the federal code, some have been updated in 2008, some have been updated in most recently as 2016. And just as technology changes and some of the definitions, it now includes electronic transmission and communication where that wasn't in the 1989 version. And so just every time the language of the federal code gets updated, we don't want to have to come back and update our statute just for compliance.
Thank you.
And if the secretary would let the record reflect that Senator Cannizzaro joined us during the presentation. And Senator Hansen has a question.
Thank you, Madam Chair. I wasn't familiar with the terminologies. When you say a trap and trace device, is that the same as the Stingray type technology that the Supreme Court recently said they can't use unless they have a warrant? United States Supreme Court. Are we talking the same stuff there? Or am I mixing apples and oranges?
Teresa Hart for the record. A stingray or there's another term, it's a triggerfish, sorry, not pufferfish, triggerfish. Those are actually wiretap devices, and so that allows you to obtain the contents of the communications in real time. And that is a much higher burden. So under the federal law, you have to have probable cause to believe that a crime has been, is being, or will be committed in the future. You have to have probable cause to believe that the contents of the communications that you're trying to intercept have evidence of the crime that has been, is being, or will be committed. And then you also have to demonstrate that all less intrusive methods have been attempted and have failed or are unsafe to pursue. So triggerfishes and stingrays, apologies, those are forms of wiretap communications, which is actually the contents of the communication, which is a much higher burden to prove. This doesn't obtain any of the contents of any of the communications from a pen register or a trap and trace. It is only the data conveyed generally to your utility company of the phone number that you're dialing out and the phone numbers that are dialing in. There is some other data that is directly affiliated, but that is considered phone company business records. And so it's actually information being obtained from your utility company and not from the individual possessing the phone themselves.
So are you actually raising the standard here there to make it a little more difficult to do that? I'm a little confused at what we're getting at here, because frankly, the whole stingray stuff, I actually have a bill on it, and I don't know if it'll come to this committee or not, but the fact of the matter is that law enforcement, in spite of the Supreme Court saying you have a Fourth Amendment protection against unreasonable searches and seizures, are still using that technology to trace people. Not just the communications, but literally to trace their movements in different locations. But I don't know if I may be throwing something into this whole discussion that's just not really there. But yeah, I would like to find out a little bit more about the trap and trace side of this, and whether or not we're actually simply codifying existing federal law, or if we're trying to add a new level to make it a little more difficult to use those sorts of technologies in the absence of a search warrant.
Teresa Hart for the record, thank you. No, a trap and trace and a pen register. So a trap and trace.
Sorry to interrupt. But I've got some feedback that they're having a difficult time hearing you over the live broadcast. I know you guys are all trying to do your best to social distance, but if there's any way for the speakers to get closer to the microphone so that everybody watching the meeting can hear what you're saying, that would be fantastic.
Thank you for that. Teresa Hart for the record. A pen register and a trap and trace are very different from anything that takes on either contents of communications or live data. And so if we're looking at location data, the only thing that a pen register or a trap and trace device might include would be historical cell tower location data. And that is the cell tower that I use to make my phone call, but it does not have my actual location, and it's not real-time tracking. So again, it is only cell company or phone company business records and not my actual location that is currently being tracked. And again, we're not making any proposed changes to the contents of the application or the burden of proof in an application. We're only changing some of the mechanics of it. And so members of the task force who are federal officers who are already involved in these types of criminal investigations, they don't have to relay to the state or local law enforcement agent their personal information to do the supporting affidavit. They themselves can use their own personal knowledge to do the affidavit. And the other side of it is simply allowing for an electronic submission versus a hard paper submission to the court. So we're not trying to lower or raise any of the burdens. We're only trying to streamline some of the mechanics for the physical process of the application itself.
All right, well, thank you for that explanation. Thank you, Madam Chair.
Absolutely. I saw Senator Orenshaw had a question earlier. Has it been answered, or would you like to ask your question?
Chair, I'll be very brief. Thank you very much. For Ms. Hart, then under the current situation, under the 179.530, these federal officers who are on these multi-jurisdictional task forces, has there been any issue with them trying to obtain the pen registers or trap and traces? I guess I'm just trying to see what problem this is trying to fix, trying to understand that. Thank you. Thank you, Chair.
Teresa Hart for the record. Currently, if there's a multi-jurisdictional task force, if a federal agent has information that would be used to support the affidavit in support of the application, they themselves are simply unable to do the affidavit. And so they would have to communicate with the either a state or a local law enforcement officer who is currently identified as a peace officer who's eligible to do an affidavit in support. They would have to convey all of that information, and then the local officer would be the one to actually draft the affidavit in support of the application. So this would simply eliminate that middle step of reconveying the same information to various members of the same task force.
Thank you, Ms. Hart. Thank you, Chair.
All right, Senator Settlemyer.
Thank you, Chair. I was curious. I'm a little bit concerned about this. They call it, I guess, metadata that is being collected, and then you're indicating that this will change how it is submitted. It'll be allowed to be more electronically submitted, and what safety protocols and security do we have to make sure that this metadata isn't intercepted or utilized by somebody else?
Teresa Hart, for the record, I apologize, are you asking for the data for the security of the electronic submission of the application, or are you inquiring about the metadata that could be obtained in a pen register or trap and trace?
Concerned with the concept of the metadata that is being collected for the concept of a criminal case. How will that information be conveyed to the court? It will be electronically, or how is that done, considering that there may be other uses for this information to be intercepted?
Jessica Adair, for the record. The only thing that this bill does is change the application, the affidavit that's submitted to the court, allowing that to be submitted electronically. So the normal processes for receiving the information collected in a trap and trace or pen device, including the metadata, would not be changed. That would not be changed by this. The only thing that would be changed is some courts allow you to submit your affidavit through their electronic system. Some courts make you print it out, sign it, walk up to the courthouse, and hand it to the legal secretary. So we're just trying to help courts understand that they can use that electronic submission for the affidavit and for the application. Some courts will not allow us to submit things electronically unless it says in state law that they can do so. So all of the information that's received, none of that will be changed in this bill.
So then, in other words, if I could, Madam Chair, for elaboration, this will just basically force the judicial department to come into the next century and accept the application process electronically.
Jessica Adair, for the record, yes, that is a very diplomatic way of putting it, Senator.
Really appreciate that. Thank you, Chair.
Absolutely. Senator Harris, go ahead.
That was a previous hand raise. I will take it down.
All right. In that case, I think that nobody else has any questions. All right. Then we will move on to testimony in support. Again, we will be doing support testimony for 10 minutes, and each speaker will be limited to 2 minutes.
Thank you, Chair. To testify in support of SB 41, please press *9 now to take your place in the queue. Once again, to testify in support of SB 41, please press *9 now to take your place in the queue. Caller with the last 3 digits 283, please slowly state and spell your name for the record. You will have 2 minutes and may begin now. Once again, caller with the last 3 digits of 283, please press *6 to unmute yourself, then slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Marcos Lopez, Americans for Prosperity, Nevada, MARCOS LOPEZ. The changes in this bill are not earth-shaking, but is a positive step in the right direction. The removal of the dated provision clause is vital because federal laws have changed multiple times since then and now provide additional procedural protections, and allowing the electronic submission just gives the advances necessary to keep up with the technology in today's date. So I hope that we vote in favor of this legislation.
Thank you, caller. If you have just joined us, we are currently in support on SB 41. To testify in support of SB 41, please press star 9 now to take your place in the queue. And Chair, at this time, there are no more callers in support.
Okay, then we will move on to testimony in opposition of SB 41.
Thank you, Chair. To testify in opposition of SB 41, please press star 9 now to take your place in the queue. Once again, to testify in opposition on SB 41, please press star 9 now to take your place in the queue. And callers, if you've just joined us, we are currently on opposition on SB 41. To testify in opposition, please press star 9 now to take your place in the queue. Caller with the last 3 digits 611, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon, Chair and members of the Senate Judiciary Committee. This is John Piro, John-Piro, from the Clark County Public Defender's Office. We are in opposition at this point. We are still in discussion with the Attorney General's Office about potential amendments to this bill. So per the rules of the committee, we're in opposition, but hope to move out of the opposition position. We have no problem with making things electronic and speeding that process up. There's just some other things that we're trying to discuss with the AG's office to make us more comfortable with this legislation. And with that, I'll conclude my testimony.
Thank you, caller. Caller was the last 3 digits 212. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon. My name is Sarah Hawkins, S-A-R-A-H, last name H-A-W-K-I-N-S. I am the president of Nevada Attorneys for Criminal Justice, or NACJ, and I'm speaking in opposition to SB 41. To echo Mr. Piro's comments, we are hopeful that we can get to a place where we are not in opposition to this, and talks with bill sponsors are ongoing. But I will note that our primary concern is the lack of parity in terms of protecting privacy interests between the federal law and the Nevada law. Just a couple of examples. There is no general prohibition in using pen registers and trap and trace devices in Nevada law. The federal law has that general prohibition, and that should be where we start. Protecting privacy interests is where we should start. Definitions of trap and trace devices and pen registers should also be reflected in Nevada law and concomitant with those provisions in the federal law. And in addition to that, we should be codifying the prohibition on getting content from these devices. That is also reflected in federal law. So those provisions that add to the baseline and starting point of privacy interests is what NACJ would like to see. But for now, we testify in opposition, and that will conclude my comments.
Thank you, caller. And callers, if you've just joined us, we are currently in opposition on SB 41. To testify in opposition, please press star 9 now to take your place in the queue. Caller was the last 3 digits 318. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now. Once again, caller with the last 3 digits 318. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now. Moving on, caller with the last 3 digits of 318.
Sorry,
are you ready? Oh, go ahead. Yep.
Can you hear? Sorry, it muted me again. This is Kendra Birchie, Kendra Birchie, Bertschy. Good afternoon, Chair Scheibel and members of the Senate Judiciary. I want to start by first thanking the Attorney General as well as his staff for speaking with us and meeting with us and answering several of our emails going back and forth regarding this bill as well as their other bills. We do have some concerns, but I would just want to note for the record that we do agree with the modernizing the process in order to obtain these warrants, and our concerns are primarily with just ensuring that we are protecting the privacy interests of our citizens. And if we are focusing on ensuring that our Nevada statutes are in line with the federal law, then that is our goal of to try to mirror that process. So I do appreciate all the conversations that we've had at this point due to the rules. We are testifying in opposition, but hope that we can move our opposition away and perhaps into support. So with that is my testimony. So thank you for your time.
Thank you, caller. Caller with the last 3 digits 106, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
My name is Emily Driscoll, E-M-I-L-Y, last name D-R-I-S-C-O-L-L. I'm with the National Lawyers Guild. I am a student at Boyd Law. I oppose SB 41 because most of the community groups are still in negotiation with the Attorney General's office about the bill. Privacy interests are really important in a digital age, and while modernizing the criminal process is important, privacy should be just as important. In a bill like this, it's important also that we're specific. Broad language could be really compromising to general privacy of Nevadans. I yield my time.
Thank you, caller. If you have just recently joined us, we are currently on opposition testimony to SB 41. To testify in opposition, please press star 9 now to take your place in the queue. And Chair Scheibel, at this time, there are no more callers to give opposition.
Thank you, Mr. Kyle. We will move on to testimony in the neutral position on SB 41.
Thank you, Chair. To testify in neutral on SB 41, please press star 9 now to take your place in the queue. Once again, to testify in neutral on SB 41, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to give neutral testimony.
All right, thank you. That being the case, I will now close the hearing on SB 41. I will open the hearing on SB 50 and ask Mr. Attorney General and his staff to go ahead and begin their presentation of the bill whenever they are ready.
Good morning, Chair Scheibel and members of the committee. For the record, my name is Aaron Ford and I am your Attorney General. Joining me virtually and in person are members of my staff. I have a few with me today: Chief of Staff Jessica Adair, First Assistant Cal George, Second Assistant Christine Jones Brady, and Special Assistant Teresa Hart, and as well as my Chief of Investigations William Scott Jr. It's always a pleasure to come back home to the legislature and appear before this committee. And at the outset, let me again congratulate each new committee member on your recent election win. Recall fondly my days in the State Senate and specifically on the Judiciary Committee. I wish you Godspeed as you do the people's work. And also, Nicholas and Patrick, hello, great to see you. Many have heard me discuss my office's 5 C's: consumer protection, community engagement, client and constituent services, criminal justice and reform, and constitutional rights, the protection of all of them. The last 2 C's are what bring me before you today, specifically improving our criminal justice system by, this time, focusing on the 4th Amendment and its warrant requirements. The 4th Amendment of the United States Constitution provides that no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. A lawfully issued warrant gives law enforcement lawful authority to enter premises without consent of those controlling the property. In practice, law enforcement officers use two methods to gain entry into premises covered by the warrant. First, via what's commonly known as a knock and announce, or second, under a what's called no-knock warrant. You're probably familiar with both of these. Knock and announce is the dramatic entry when law enforcement bangs on the door, yells in essence, police search warrant, and gives the subject an opportunity to open the door. A no-knock warrant, on the other hand, is what we call a dynamic entry, where police try to capitalize on the element of surprise by securing the premises before the subject has the opportunity to respond. With a no-knock entry, officers explosively breach the entryway and swarm the premises before the subject has an opportunity to react. The Supreme Court of the United States has upheld the use of no-knock warrants. In 2003, the court held that, and I quote, when officers have a reasonable suspicion that knocking and announcing their presence under the particular circumstances would be dangerous or futile, unquote, and quote, when a warrant application gives reasonable grounds, unquote, that these dangerous or futile circumstances exist, then a magistrate judge is acting within the Constitution to authorize a no-knock warrant, a no-knock entry. But the constitutionality of a practice is merely the threshold inquiry that we must analyze. It is not the sum total of the analysis. We know that in certain circumstances, no-knock warrants can be problematic. As I mentioned a moment ago, the purpose of a no-knock warrant is to secure persons, premises, or evidence before the subject is able to respond. But from the perspective of the subject, he or she only knows that armed persons have violently entered their premises. And in those immediate moments, he or she does not know their intent. An armed subject may reasonably believe that the officers serving the warrant are home invaders and respond accordingly. The situation is therefore rife with danger for both law enforcement and subjects. In 2017, the New York Times conducted an investigation and reported that, and I quote, at least 81 civilians and 13 law enforcement officers died in such raids from 2010 through 2016. Scores of others were maimed or wounded, unquote. One of the most recent examples of such a tragedy is the killing of Brianna Taylor in Louisville, Kentucky. I need not go into the details of that incident, as I am sure all committee persons are quite familiar with it. Suffice it to say, the police who were investigating Taylor's apartment had a no-knock warrant to enter. An execution of that no-knock warrant led to the death of Mrs. Taylor. Her death gave rise to me bringing this bill forward. The state of Nevada's largest law enforcement agencies significantly limit the use of no-knock warrants, except in the most urgent circumstances. For example, at least one law enforcement agency generally prohibits dynamic entry except for a deliberate hostage rescue caused by immediate life rescue exigency. And under these circumstances, a no-knock warrant is not necessary. As a result of this policy, the agency has not executed a no-knock warrant in years. Another agency has similarly adopted policies that constrain when a no-knock warrant is appropriate and requires several levels of sign-off. As with the first agency I mentioned, in practice, no-knock warrants are extremely rare with this agency as well. In short, Nevada's police have done a good job of policing themselves on the use of no-knock warrants. However, the restraint we have seen exercised here is the result of internal policy, not law. SB 50 seeks to enshrine these good policies into law by providing that no-knock warrants can only issue in very limited circumstances. First, I will address the elephant in the room. I know that some are calling for a complete prohibition on the use of no-knock warrants, particularly in light of the events in Kentucky last year. But in my judgment, there are rare examples, some of which we cannot foresee, when a no-knock warrant may be justified and needed to protect life if planned and executed appropriately. Thus, I don't, through this bill, either as introduced or as eventually amended, seek to ban no-knock warrants in their entirety. To be sure, that remains within the purview of the Judiciary Committee, but that is not my intent through this bill. That said, the solution we are presenting today sets up a framework that ensures no-knock warrants are utilized as sparingly as possible, with the equally important imperatives of officer safety and public safety. For the purposes of this hearing, we have filed an exhibit with the committee. As indicated on the first page of the exhibit, the amendments here should not be considered final at this time. Our intent is to continue convening meetings with stakeholders in the immediate future so that we can hash out the remaining sticking points on this bill. I'd like to thank the many stakeholders who contributed to this amendment and welcome the collaborative feedback of other stakeholders. While these warrants are rarely used, this is a subject of great debate because the stakes are so high. We must get this right. While this version may not be perfect right now, it is better than what it is in current law. So I look forward to working with stakeholders and the members of this committee as we have a vested interest in ensuring that the legislation is the best possible version it can be to protect public safety and our constitutional rights. While I'm prepared to discuss the bill as introduced, I do believe it would be most useful to address the proposed amendment because it is now the operative document from which additional negotiations will occur. And so with the chair's permission, I'd like to turn to the committee's attention to section 1 of the bill. Under existing law, a prosecutor may ask the magistrate to issue a summons in lieu of a warrant for arrest. The amendment to section 1 in the exhibit gives the magistrate the ability to sua sponte, that is, on its own volition, issue a summons instead of a warrant, regardless of whether or not the prosecutor made such a request. This provision, however, will be subject to further discussion in our further stakeholder meetings. For section 2, I'd like to discuss the version provided in the exhibit as well. And first and foremost, this section explicitly states the 2 factors that must be considered before a no-knock warrant should issue: public safety and officer safety. A no-knock warrant should not be utilized for misdemeanor crimes, property crimes, or simple drug possession crimes, period. Therefore, law enforcement agencies seeking a no-knock warrant should first prove that there is a significant and immediate threat to public safety that justifies the use of a no-knock warrant. For example, an imminent attack of terrorism. The other element that must be shown is officer safety. That is, a knock and announce entry would create an inordinate danger to officer safety or to the safety of other persons. The amended version of section 3 lays forth 6 elements that a warrant for a no-knock warrant, that a warrant for no-knock should contain. I will tell you that in developing this list, I consulted with our Chief of Investigations, a 29-year veteran of the Las Vegas Metropolitan Police Department who retired as a captain. Chief Scott is of course available to this committee to discuss these elements, and they are as follows. First, the affidavit must describe the probable cause that establishes the charged crime is a felony, and that the facts in this particular case show that there is a real risk to public safety. Probable cause is a constitutional minimum for any warrant. And as I indicated earlier, we should utilize no-knock warrants only for the most serious crimes, not for misdemeanor crimes, property crimes, or simple drug possession crimes. The affidavit must explain, number 2, the affidavit must explain why in these particular circumstances, a knock and announce warrant just won't work. In other words, why do we need a no-knock warrant here? The third requirement being the warrant application must specify whether the warrant can be executed during daylight hours, and if not, why it cannot be. This is exactly in line with the normal warrant application, where the affiant must explicitly seek permission to execute the warrant between 7 p.m. and 7 a.m. Fourth, the affiant must describe the investigation to date and what evidence uncovered in the evidence indicates that a no-knock warrant is necessary. This is closely related to the constitutionally necessary probable cause standard that underpins every valid warrant. Fifth, the affiant must certify to the court that nothing less than a no-knock warrant would be sufficient in this circumstance. Again, a no-knock warrant should be a last resort. A certification to the court carries a legally significant and consequential weight to the assertion. And lastly, the affiant must certify that the officers effecting a no-knock warrant are properly trained to do so. No-knock warrants are uniquely risky activities and should be utilized only by highly trained officers. Section 4 of the amendment describes a few criteria on how a no-knock warrant should be executed. First, we get that no-knock warrants are utilized when knock and announce isn't feasible. However, law enforcement should still let occupants know who they are as soon as possible. Once entry has been made, all surprise is gone. Officers should therefore reduce the risk of misidentification to the greatest extent possible by identifying themselves as law enforcement as soon as it is practicable to do so. Second, officers must utilize the least force necessary to effectuate dynamic entry. There's a famous story in law enforcement about a force that used a bulldozer to gain entry through a living room wall. Although there may be times that this is necessary, although I can't articulate one right now, given an option between knocking down a door and knocking down a wall, the law enforcement should always use the least destructive viable option. Third, officers should wear body cameras whenever practicable. This is consistent with existing law. Fourth, before executing a no-knock warrant, officers should always make a last-minute assessment to determine whether the need for a no-knock warrant is still present, and if the circumstances at any given moment create a risk to innocent persons that was not previously ascertained or present. Madam Chair, I submit to you that none of these conditions are unreasonable. None of these conditions place a burden on law enforcement that isn't commensurate with the risk involved in a no-knock warrant. And all of these conditions firmly position no-knock warrants as an option of last resort. These are common sense steps that any law enforcement officer planning to utilize a no-knock warrant should be considering anyway. This information also assists the court to make an educated decision as to the need for a no-knock warrant in the first place. Section 5 of the amendment, to be frank, is a bit more contentious. Section 5 provides that if sections 2 and 3 were not satisfied, then a defendant may seek to suppress any evidence found as a result of any warrant that stems from the defective application, that is, any fruit of the poisonous tree. This is, however, merely a rebuttable presumption. For this section to apply, a criminal defendant must first articulate how the warrant application or execution did not meet the elements I've recently presented. State prosecutors can overcome that challenge by showing that any defects do not amount to constitutional violations. There's a significant body of law at the state and national level surrounding what constitutes a Fourth Amendment violation and what does not. And both sides will have the opportunity to make their case if need be. Let's be clear on this. Law enforcement should always make every effort not to violate constitutional rights. That is our duty as sworn officers of the law. Any due process requirements that we allow defendants to make all non-frivolous arguments that they are entitled to make. In practice, defendants can and do challenge the legality of normal warrants in the majority of cases where it would be beneficial to their case. This wouldn't be any different. The last sections of the amendment are merely conforming changes consistent with the issues addressed above. Those of you in the legislature know my process as well. A goal in legislation is to invite the input from all stakeholders, compromise where we can, and hold strong where we must. In this bill, that process is not yet complete, but I am confident that we will produce a final product that is reflective of my priorities as Attorney General, which means a bill that elevates constitutional protections above all else, ensures the safety of law enforcement, but is responsive to community concerns regarding no-knock warrants. I look forward to continuing to work with stakeholders and legislators on this bill, and I'd be happy at this point to answer any questions you may have. Thank you again.
Thank you so much, Attorney General Ford. Members of the committee, do you have questions on this bill? I see a question from Senator Hansen. Go ahead.
Thanks, Madam Chair. Attorney General, great to see you again. The amendment, are you considering that a friendly amendment, or I don't see the origin of it. Did it come from somebody in law enforcement, or what's the background of the amendment, proposed amendment?
Great to see you again, Senator Hansen, and please tell your better half that I said hello. You are indeed the bitter half. Bitter, not better, bitter half. That's it. To answer your question, I have not categorized the amendment as either friendly or unfriendly at this point, Senator. We are in negotiations with all interested parties. The amendment was one presented to us by one side, if you will, of the issue here, predominantly being from the ACLU, the Nevada Association for Criminal Justice, and the public defenders, among others. They raised some very good points that we think are very valid for purposes of this discussion, and included it. We didn't have an opportunity, however, Senator Hansen, to have a thorough discussion with, for example, my colleagues in law enforcement and the district attorney's office, and therefore, long answer, Senator, this is neither friendly nor unfriendly, but we do receive it as an opportunity to continue discussions around presenting a bill at the end of the day that hopefully the chair will entertain in a work session.
Very good. Okay, you guys are still working it out. It's really kind of what I want to find out, whether or not you were just, no matter what. Sounds like you're still working through the process. Thank you, Madam Chair.
Yes, sir.
Absolutely. Senator Orenshaw.
Thank you, Chair, and thank you, General Ford and your staff, and really appreciate all the hard work, bringing all the stakeholders from law enforcement defense side on this bill. I think it's very important, and I think our constituents really want to see something in this area move forward and get signed by the governor. You mentioned exempting misdemeanor allegations and felonies, and I hope that as negotiations continue, maybe considering exempting the nonviolent felonies as well, because certainly Nevada statutes have many nonviolent felonies where perhaps that should also be considered along with the misdemeanors. I guess more of a suggestion, but I appreciate all the hard work of the Attorney General's office, bringing all the stakeholders, and thank you, General Ford. Thank you, Chair.
Senator Orenshaw, thank you so much for that recommendation, and to you as well. Chair, your better half, I said hi, you're bitter too, by the way. But your suggestion is duly noted. I'm certain that I have my colleagues jotting that down, and those both in neutral opposition and in favor will likely take that into consideration as we continue our negotiations. Thank you.
Thank you, General. Thank you, Chair, and I will pass that on to my much better half. Thank you.
Thank you both. And Vice Chair Majority Leader Cannizzaro has a question.
Thank you, Chair. And it's always good to see you, General Ford, and always good to have you before the committee. We definitely miss you here in the legislative building, but good to see you over there.
Yes, ma'am.
I had a question just about the piece that I think is just in the amendment, where there would be a requirement for the officer to certify they're trained in tactical or dynamic entry operations. How would you foresee, what would qualify under that, and how would you foresee that operating? Would it be just part of the application? Would there be some process for officers to kind of apply for that? How would you foresee that working, that piece of it?
So I appreciate that question. I'm going to offer a couple of thoughts, but I'm going to kick it to either Chief Scott or to someone in the South to address this. Here's what I can tell you from anecdotal experiences. When I took a tour with Elko Police, I was in the car with an individual who was trained in this, and there was literal training, and I want to say certification. That may not be the right phraseology, but who talked about the need for having such tactical training in circumstances like this. And so my understanding, again, I'm going to kick it to Chief Scott, and Kyle George should discuss further, is that departments are readily available and capable of ensuring that the people who are executing these do have that training, but the certification component is going to be a requirement in law at this juncture to ensure that those who are applying for these forms of warrants are in fact certified and trained in it. So let me offer the mic to Chief Scott first, and then to whomever else on there that would like to chime in.
Good afternoon. This is Chief William Scott, Chief of Investigations for the Attorney General's Office. Yes, when you look at that question surrounding training, I think it's important that these officers have the adequate training to effect such warrants. There are a number of what we call squads or sections within law enforcement agencies who are not properly trained at the level of our SWAT officers that are trained, that do this on a daily basis. And as part of their normal daily routine, that's what they're trained in, and to do is execute search warrants and be able to effect these types of warrants effectively and efficiently. It's problematic when you have individuals who are not training together on a daily basis and not in sync with each other as they conduct these types of entries. And it poses much more of a threat to those officers and to the community when they're not properly trained. So adding a component into this bill where these officers have to articulate the type of training that they had is very important.
Jessica Adair for the record. To your question, Vice Chair, about the mechanics of the bill, we're not anticipating at this time to require anything beyond a certification from the officer to the court. Should that officer in that application or in the affidavit in support of the application for the warrant seek to add additional detail, I think that would be helpful for the magistrate to make an educated decision about the appropriateness of that warrant. But at this time, all that this amendment is requiring is a certification from the officer that they are trained to do so.
And if I could offer one final comment, just to let you know, we're not preaching without practicing. My chief, upon being hired, ceased all internal practices of dynamic entry until our folks got trained. So we practice what we preach in this area, and I just want to share that as well.
And thank you, Attorney General Ford and Chief Scott. I appreciate that, and I think that makes a lot of sense, and I agree. And I'm certainly familiar with different training that goes on for some of these law enforcement groups that are highly trained in some of those entry pieces. And so I just wanted to make sure we were clarifying that, and then thank you, Ms. Adair, for clarifying the certification piece, because I think that's important for us to have some clarity on. The other question that I had was with respect to the rebuttable presumption. And the way that I'm sort of reading this, it almost seems as though, and I guess if you could elaborate just a little bit on this piece of it. I understand the issue, and obviously we don't want evidence to be obtained illegally or in violation of a Fourth Amendment right and then submitted to a court. And I think to your point, Attorney General Ford, current status of the law, when things are obtained in violation of constitutional rights, specifically the Fourth Amendment, those are excluded. But there is sort of, I think in this bill, as I'm reading it, a rebuttable presumption that exists if you prove the Fourth Amendment violation, and that's in the amendment piece of it, not in the text of the bill. And so I'm wondering, the way I read that is, you would have to prove there's a violation of a constitutional right, and then there's still this additional inquiry as to whether or not that rebuts the presumption that if it was obtained, that it wouldn't be admitted. But that seems in some ways duplicative of current Fourth Amendment search and seizure law. And in some ways, I think it could be a little confusing when it's sort of a rebuttable presumption, but then also if you prove these constitutional violations. So can you talk a little bit about how that would work and the interplay with what we would traditionally see in a sort of a motion to exclude under the Fourth Amendment?
Thank you, Madam Vice Chair, for the question. And I will again defer to comments from my Southern counterparts there to discuss this further. I will say that you may recall from my days in the Senate, running a bill that addressed fruit of the poisonous tree stuff as it related to racial profiling, at least as I articulated it. We were unable at that juncture, if you recall, Madam Vice Chair, to figure out a way to facilitate change in the law in that regard, and that's unfortunate. What we look to do in this bill, however, is to ensure that we can protect the constitutional rights of those who are subjected to these no-knock warrants via this rebuttable presumption, the intricacies of which are still being worked out. So I'm going to have my colleagues in the South speak to this issue, but I'll also suggest that those who presented this amendment likewise speak on that issue as to the way that they saw it working as well.
Thank you, Attorney General Ford. Thank you, Madam Vice Chair. For the record, Kyle George, First Assistant Attorney General. Madam Vice Chair, I believe that as written, the amendment says that there are certain procedural steps that need to take place, sections 2 and sections 3. And an application, an affidavit in support of an application must contain certain materials within it. And then the warrant itself must be executed in a certain way. I believe as written, section 5 provides that if a defendant that is arrested pursuant to this bill believes that there was a defect in process at any point, they can challenge based on that defect. The prosecuting attorney then has the opportunity to say, no, that is a procedural defect, not a substantive constitutional defect, which will overcome that challenge. That I believe that is as it should be. The Supreme Court has opined on many occasions that some procedural defects do not amount to constitutional concerns, and others do. And that will be a case-by-case inquiry that can be made at any by any defendant and overcome by any prosecutor.
And thank you, Deputy George. I think that is my question, is that it almost seems to be duplicative of what we would typically see in Fourth Amendment litigation or Fourth Amendment law in terms of certain procedural defects that do rise to that constitutional level would result in exclusion. And so the way I read this, or at least in as far as you've explained it, it seems as though that's what we're articulating here. And I just wanted some clarity on whether we were trying to do something a little different, or if we're saying that this is mostly in line with that, because I think that's exactly, I think the point was, are we doing something that is different than what we see in Fourth Amendment litigation when we're talking about excluding evidence?
Thank you, Madam Vice Chair. For the record, Kyle George. The intent is that it is in fact consistent with existing Fourth Amendment practice, not perhaps not duplicative per se, but certainly consistent. The plan and intent here is not to create a whole new standard.
Great, thank you so much. I really appreciate it.
Senator Pickard.
Thank you, Chair. All right, thank you, Chair. As I'm listening to the colloquy, particularly as we talk about the amendments, it sounds like we may be conflating the amendment to apply to all of these entries and not just the no-knocks. I'm trying to go through the amendment really quickly, but maybe I could just ask the general statement. Does the amendment apply to all of these entries, any high-risk entry of any type, or is it just the no-knock? And then, of course, if we're serving a warrant on drug traffickers or you know, where we currently have a no-knock, does that still apply? I'm just trying to get my arms around the amendment.
Thank you, Senator Pickard. And shall I begin by saying hello to your better half? I will. You know what your description is. In any event, yes, this only applies. My intention is that this applies to no-knock warrant. And if the amendment does not clearly address that, we will ensure that what is brought before you, hopefully again in a work session, clarifies that. But this is not intended to apply outside of the no-knock warrant circumstance, which, as I've indicated incidentally, is very seldom used anyway. It is not something that has taken place on a large scale basis, and in fact, is something that is very minimally used in Nevada.
I appreciate that, Madam Chair. If I could just follow up real quick, thank you. I just want to make sure that before we get to a work session, that y'all will circulate the final amendment, the final draft of the language, so we're not having debates at the work session about alternate versions, but we'll have something solid to vote on.
Sorry. I will absolutely report for the record, absolutely commit to follow whatever the chair's rules and requirements are for a work session. If that's submitting a document well in advance of which, we will do so. But even beyond that, Senator Pickard, we're always happy to hear from you directly and engage you in the discussions around this issue. So keep that in mind as well.
I appreciate that. And this isn't my practice area, so I'm just gleaning as I go. So I appreciate that. Thank you.
Understood.
All right. If nobody else has any questions, I just have one question. And it relates to language that's used twice in the amendment. I'm looking specifically at page 4 towards the middle. It starts with the magistrate shall not issue a no-knock warrant to search the person or place named in the search warrant unless the affidavit or affidavit sworn to before the magistrate. And then the green text indicates the standards that have to be met in order for the no-knock warrant to be justified. And I'm curious about the exact language that's utilized here. And particularly, I noticed that the underlying crime has to threaten public safety, but then the announcement of the execution of the warrant has to create an imminent danger to the life of somebody. And I'm wondering why those two standards are different, if that's intentional, or if this is language that you, Mr. Attorney General, and others are still working through.
Thank you for the chair. Thank you for the question, Chair Scheibel. I want to review the language to see if I can respond appropriately, unless my colleagues in the South have a better understanding of the question and can address it. Looks like my first assistant, Kyle George, can.
Thank you, Attorney General. Thank you, Madam Chair. I believe the two parts, are you talking about section 1? Sorry, sub 1 of section 2 on page 4?
Yes, exactly.
Thank you. So I think there are two different aspects. First of all, the first part of it demonstrates the underlying crime involves a significant and imminent threat to public safety. That goes to concern raised by Senator Orenshaw previously, that this not be used for even felony crimes that may not be serious. We intend to this be limited in scope to crimes that are felony level, it's not below, and within that, the subset of felony crimes that implicate a significant and imminent threat to public safety only. So again, you may have, for example, large possession of drugs, which would in fact be a felony crime, a high-level felony crime, but there may be no indication on the record or no evidence that is uncovered through the investigation that there is a safety issue in going into effect irregular knock-and-announce warrant. So the first part of that is intended to be a limitation on only the most serious type of crimes. And then the second part of it is the issue of who's in danger when we execute a no-knock warrant here. Specifically, if the agency can demonstrate that this does place a risk on officers or perhaps another member of the public who will be present, those were the two elements that we would want to focus on and constrain the use of no-knock warrants to. And to be clear, there's nothing in this bill that prohibits the use of regular knock-and-announce warrants when it is more appropriate. So if an agency isn't able to meet the standards put forth in this bill, they can still resort to a traditional knock-and-announce warrant. I hope that's responsive.
It is, and it helps, but so I just kind of want to pose a bit of a rhetorical question that to explain my thinking here. What I'm worried about is whether a crime that is endangering, and I'm thinking specifically of domestic violence issues, because that's one place where I have seen no-knock warrants utilized in the past, is, you know, if you have somebody who is threatening the safety of their partner and nobody else, would we consider that a threat to public safety? Or is a threat to public safety to endanger a whole crowd of people, to drive recklessly through the freeway and put multiple people in danger at the same time? Or can public safety be just one person? And then going further, if we're going to, you know, suggest that it is, and move on to the next prong, which is asking who would be threatened by giving notice, I think this standard is very high to say that it has to create imminent danger to the life of the officer or another person. Because if an officer isn't sure whether the subject who's barricaded inside a house is armed or not, then I don't know if they can articulate that their life is in danger, or simply that their safety is in danger and their life might be in danger. And I worry about how we're going to address all of those specific questions when the first case comes up under the language that is ultimately adopted.
Madam Chair, you said it was rhetorical, but it's a fantastic question and exactly the reason why we will continue working with the interest groups, especially those who presented the amendment, right? As we work through those types of circumstances. So thank you for the question and thank you for saying it out loud so that those listening and those presenting this amendment and those who are going to be working with us to come up with a better form can help us to address it at our collaborative meetings.
Thank you. I appreciate it. And I see Senator Harris has a question.
Good afternoon.
I hoped I'd get a question from my senator. I really did. But be nice. Remember, I used to sit where you are, so, be nice.
That's right. Well, listen, I'm actually going to let you down. I don't have a question for you today, but I just wanted to thank you for taking on this obviously challenging topic and bringing the bill before us. It's appreciated.
Senator Harris, I appreciate that. But let me say this. It hasn't been challenging per se. Frankly, I think law enforcement and those who work with law enforcement, either together or on the other side, recognize the importance of this issue. Brianna Taylor, her killing, I got goosebumps, bad ones, as I talk about her name out loud, showed us a reason for having this discussion. I am grateful that our law enforcement in the state doesn't utilize this extensively, but that's a matter of practice and policy. Again, we're here to ensure that our state represents the highest standard when it comes to the protection of constitutional rights of all of our residents. And this bill accomplishes that, which is the reason why, again, I didn't find this a difficult one to tackle. And I look forward to, again, working with the interest groups to ensure we can get this done.
Thank you so much. And thank you to everybody for contributing your expertise, your comments, and your questions from the committee. I don't see any more questions at this time. So we will move on to testimony in support of SB 50. As I mentioned earlier, each person will be limited to 2 minutes. That is a minimum, not a maximum. You are welcome to get on the phone and simply tell us that you agree with the caller before you or all of the callers before you. We will take 10 minutes of testimony in support of the bill total, 10 minutes in opposition and 10 minutes in neutral. We encourage you to submit your testimony in writing as well, or instead of testifying online. Testifying verbally. I know that we already have online a couple of pieces of testimony that I will be sure to review, and I would strongly encourage all of the members of the committee to review. And with that, I will turn it over to Mr. Kyle at BPS for our first caller in support of SB 50.
Thank you, Chair Scheibel. To testify in support on SB 50, please press *9 now to take your place in the queue. Once again, to testify in support on SB 50, please press *9 now to take your place in the queue. Caller with the last 3 digits 505, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hello. Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Chris Wong, CHRISWANG, and I'm a member of the Las Vegas community. I'm an educator here, and I've lived in Nevada for over 20 years, and this is my home. I'd just like to put forth my support for Senate Bill 50. And while I support the ban of no-knock warrants in Nevada, I believe the amendments the Attorney General's office is suggesting to Senate Bill 50 is the first step in the right direction. A lot of people became aware of no-knock warrants last March after the issuing of a no-knock warrant resulted in the senseless death of Brianna Taylor, as the Attorney General already mentioned. If no-knock warrants are allowed to continue, more lives of innocent citizens will be in danger. Since officers are entering a citizen's home without prior notice, these intrusions are often mistaken as burglaries or home invasions. Nevada is a stand your ground state and adheres to the Castle Doctrine, which explicitly states under Nevada Revised Statute, Chapter 200, Number 120, that a citizen may use deadly force against intruders, even if they do not believe their life to be in danger. No-knock warrants as they exist now not only endanger the lives of ordinary citizens, but also the lives of law enforcement. Moreover, Brianna Taylor's case is not the only case where no-knock warrants have resulted in the violation of American civil rights. To name a few other cases, a 19-month-old child was badly burned by a flashbang stun grenade during the execution of a no-knock warrant in Cornelia, Georgia in 2014. In another case, in Killeen, Texas, a man shot and killed a police detective outside his home during execution of a no-knock warrant on May 9, 2014. In yet another case, 2 former Los Angeles Police Department officers had pled guilty to running a robbery ring from 1999 to 2001, which used fake no-knock warrants as a ruse to catch victims off guard. Currently, 3 states already ban no-knock
I
warrants.
believe that takes
Nevada has
2
the
minutes.
opportunity to fix
Thank you,
this
Mr. Wall.
before it's too late. Thank you.
Thank you for your testimony. Next caller, please.
Thank you, Chair. Caller with the last 3 digits, 695. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now. Once again, caller with the last 3 digits of 695. Please press *6 now to unmute yourself, then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Chair Scheibel and members of the committee. My name is Holly Wellborn, HOLLYWELBORN. I'm the Policy Director of the ACLU of Nevada, testifying in support of the amendment on file for SB 50. The ACLU of Nevada, the Nevada Attorneys for Criminal Justice and Public Defenders presented an amendment to the Attorney General's office and accepted some changes to that. We understand that the AG's office is still in contact with other stakeholders on this piece of legislation, but I wanted to state on the record that we appreciate their efforts in working with us. We're not always the first person who are approached on these matters. When we're the organizations that are connected to the people that laws like this are meant to protect. So often we have lawmakers who present bills that are meant to protect families who are killed by police violence or have had loved ones who are killed by police violence, and they're the last people who are talked to. We appreciate the Attorney General's office for making communities a priority and allowing us to talk with the people that we communicate with on a daily basis to come to terms with the fact that what we're looking at is not, in fact, a complete ban on no-knock warrants in the state of Nevada, but a significant limitation that we're in a position to support at this time. I did submit some testimony some written testimony for you all to consider that goes through some of the technicalities of why we're supporting this amendment today. But I think it's important to talk about what happened to Brianna Taylor. Brianna Taylor galvanized nationwide protests for racial justice after she was brutally and senselessly killed by Louisville, Kentucky police during the execution of a no-knock warrant. Plainclothes police officers descended on her apartment. They forced entry without announcing themselves. Her boyfriend, exercising his Second Amendment right to protect his home, had no idea that this was law enforcement.
And
Police then blindly fired shots into her home. Oh,
that's 2 minutes. Thank you.
That was the 2 minutes? All right, thank you.
Thank you, caller. Caller with the last 3 digits, 611. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon, Chair and members of the committee. This is John Pirro from the Clark County Public Defender's Office. I'm going to speak fast so that impacted community members will get time to speak. We will say that we are grateful for the Attorney General's office for working with us on this issue and to continue talks. We support the amended version and are more than happy to continue talks to make this the best bill possible, because reducing no-knock warrants like other jurisdictions have both protect public safety, protect officers, and strengthen community trust in our police, which is desperately needed after the summer that we've had, both in the North and the South. Thank you, and I yield my time.
Thank you, caller. Caller with the last 3 digits, 151. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon, and thank you to the committee for the opportunity to provide public comment on this matter. My name is Denise Bolaños, DENISE-BOLANOS, and I'm a member of Return Strong. And I would like to encourage the support of the proposed amendments on SB 50, as the no-knock warrants as they stand now most often lead to confrontation that so many times ends in unnecessary tragedy, as we have all witnessed time and time again. I picture myself alone in my home with my children in the middle of the night, and if I hear that my door is being broken down, it does not matter that it's a burglar or the police or the wrong address, because I won't immediately know that difference. What I do know is that I'm going to react the same way, regardless of what that cause is, in order to protect my children and myself. And that reaction will most likely be instinctual and confrontational. And sadly, as we know, it'll probably get me killed. There are other ways for law enforcement to achieve the results they're looking for. However, once a life has been taken, whether it's a civilian or a member of law enforcement, there is no way around that, and there is no coming back. Please support the amendments of SB 50 and save lives. Thank you.
Thank you, caller. If you've just recently joined us, we are currently on support of SB 50. Please press *9 now to take your place in the queue. Caller with the last 3 digits 130, please slowly state and spell your name for the record. You will have 2 minutes and may begin now. Once again, caller with the last 3 digits of 130, please press *6 to unmute yourself, then slowly state and spell your name for the record and may begin now.
Good afternoon. For the record, my name is Christine Saunders. That's CHRISTINESAUNDERS, and I'm the Policy Director with the Progressive Leadership Alliance in Nevada, here in support of Senate Bill 50 with the amendment. At PLAN, we work to structurally transform Nevada's criminal justice system by organizing the people who have direct experience with mass incarceration and their families. We want to thank the Attorney General for bringing forward this legislation and for taking feedback on how to improve the bill with the amendment. The use of no-knock warrants began in the 1980s as a part of the failed war on drugs and police militarization. Countless stories like Brianna Taylor's, who was unjustly murdered as a result of unnecessary no-knock warrant and systemic racism, exist across the nation. Senate Bill 50 would create a high threshold for law enforcement to justify why a no-knock warrant is necessary and require that a court shall not issue a no-knock warrant unless there is probable cause. We urge that you vote in favor of the amended bill. Thank you.
Thank you, caller. Caller with the last 3 digits 646, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon, Chair Scheibel and committee members. My name is Sequila Angertok, Sequila Angkratok. I'm a student at the Bachelor's of Social Works program at UNR and a veteran of the United States Navy and a woman of color. Today I represent Fused, a diverse social justice action group of which consists primarily of social work students on the UNR campus. We're incredibly concerned about the death of, after the death of Brianna Taylor. Also through deeper education about the negative impacts of dynamic and forced entry raids on both citizens and police. And we have particular concerns about Black and Brown communities due to a history of disproportionate policing and police violence in our country. We're excited to see such a relevant bill surface. When we read the initial bill language, we felt that there were still concerns about the protections for constituents. And we felt that the provided amendment was a much better representation of needed protections for all Nevadan citizens, police and community members alike. So we stand in support, particularly of the SB 50 amendment on file. Thank you so much.
And thank you for your testimony. So that brings us to 10 minutes in support. I will remind everybody that there will be public comment at the end of our meeting, but we do have to get through 2 more positions on this bill and another bill. So I will now close public comment or close testimony in support of SB 50 and open up testimony in opposition to SB 50.
Thank you, Chair. To testify in opposition on SB 50, please press *9 now to take your place in the queue. Once again, to testify in opposition of SB 50, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to give opposition testimony on SB 50.
All right, then we will move to testimony in the neutral position on SB 50.
Thank you, Chair. To testify in neutral on SB 50, please press *9 now to take your place in the queue. Once again, to testify in neutral on SB 50, please press *9 now to take your place in the queue. Caller with the last 3 digits 196, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon, Chair Scheibel and members of Senate Judiciary. I'm Eric Spratley, E-R-I-C-S-P-R-A-T-L-E-Y, here for the Nevada Sheriffs and Chiefs Association, here in neutral to clarify our association's position, since I signed in a few days ago in a position of support for the original version of SB 50. But with the amendment and additional discussion and clarification we'll be having, we are neutral at this point. Thank you, Madam Chair.
Thank you, caller. Caller was with the last 3 digits 464. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hi, my name is Courtney Jones. It's spelled C-O-U-R-T-N-E-Y, last name J-O-N-E-S. So the folks in our state's rights to privacy and unreasonable searches, I feel like that should be honored. You know, they have to deal with ridiculous and unwarranted violence that's put upon them so suddenly. And I think about the power that's given to law enforcement, which has continued to do more harm than good. And precautionary measures that this bill is touching is kind of, to me, just the tip of the iceberg. Because, you know, no-knock warrants should be used in only the most dangerous situations. And how frequently and unsuccessfully they are, we know that that's not true. I'm not sure if you've all heard of the case of Henry McGee and Marvin Guy. One was in 2013, others in 2014. They both shot and killed a police officer in defense of their own lives of no-knock warrants. But McGee's capital murder charges were dropped and Guy's capital murder charges stood. And as you can guess, McGee was white and Guy was black. And they were both seen in front of a grand jury. And when I went to look at it, Guy's circumstances made his actions more justifiable. Also, at the beginning of this call, I didn't know that our options that are sent in were optional to be read, so that was interesting also. I personally became aware of no-knock warrants in high school when I read The New Jim Crow in high school, which, by the way, is banned in prisons, so that's maybe something you all should take a look at, too. I think it's just interesting how we're like trying to protect police today in this meeting and not really civilian lives. And we haven't talked about drug use in our country, which shouldn't even be illegal. I also think it's ridiculous that we only have 10 minutes to speak, because I'm definitely not in a neutral position about this. I support it. But I just wanted to talk and let you all know my position on this bill. So, yeah, thank you.
Thank you, caller. Caller with the last 3 digits 648. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. This is John Jones, John-Jones, here on behalf of the Clark County District Attorney's Office and the Nevada District Attorneys Association. We are currently in the neutral position, along with Eric Spratley with the Nevada Sheriffs and Chiefs. We are supportive of the original version of the bill. We have some concerns with the proposed amendment, and we have pledged to continue working with the Attorney General, his Chief of Staff, and First Assistant as we work through those issues. But at this point, we are in the neutral position. Thank you.
Thank you, caller. Caller with the last 3 digits 556. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Anne Marie Grant, A-N-N-E-M-A-R-I-E-G-R-A-N-T. I just want to speak on behalf of those who have had a loved one killed by police. My brother, Thomas Purdy, was asphyxiated to death at Washoe County Jail. They mentioned Brianna Taylor, but there are far more many names of community members who have died during no-knock warrants, such as Johnny Bolton, James Scott Reed, Duncan Lemp. In theory, no-knock raids are supposed to be used only in the most dangerous situations. In reality, though, no-knock raids are a common tactic, even in less than dangerous circumstances. There are a staggering 20,000 or more estimated no-knock raids every year. By the numbers, it's clear that no-knock SWAT raids are far more dangerous to civilians than they are to police. What might be surprising is how infrequently police officers get killed when they bust into a suspected criminal's home unannounced, and it's usually the community member who gets killed. And their families' voices are stifled, and theirs are permanently when they're killed. Thank you.
Thank you, caller. Caller with the last three digits, 963. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now. Once again, caller with the last three digits, 963. Please press *6 to unmute yourself. Yes, I can hear you, please. Yes, ma'am, please slowly state and spell your name for the record, and you will have 2 minutes.
Thank you. My name is Yesenia Moya, Yesenia Moya. I am here with Mass Liberation Project here in Nevada, and I think it's unacceptable that we only get 10 minutes to talk, especially for impacted persons. For folks in the room that do come from organizations, like I will also keep this quick. I am here in support of the amendment to SB 50.
Sorry, we're finished with support testimony. This is time for neutral testimony.
I understand, but it is completely unacceptable that we only get 10.
Thank you, Chair. Sorry about that. Caller with the last three digits, 044. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hello, thank you. For the record, my name is Desiree Smith, founder and president of More Than a Hashtag, DESIREESMITH. We focus on police terrorism and police reform here in our city. We also spread awareness on cases of those who were murdered by LVMPD. We are completely against no-knock warrants as they stand, especially since the murder of Brianna Taylor in Louisville, Kentucky. And in a perfect world, we wish we could ban them. Because we know with this so-called police reform, there will be loopholes that protect law enforcement, but reluctantly, we are in support of SB 50 as it pertains to the amendments change, such as announcing
the court testimony.
The officer's name before entering.
Next caller, please.
Thank you, Chair Tribal. At this time, there are no more callers in neutral at this time.
Thank you very much. That concludes our hearing on SB 50. I will now close the hearing on SB 50 and open the hearing on SB 62 with the reminder to everybody that there will be an opportunity for public comment at the end of this meeting after we hear SB 62. And I know that we have the Attorney General still with us to present SB 62. Please go ahead whenever you're ready.
Greetings again, Madam Chair. My name is Aaron Ford, your Attorney General. Happy to be here with you to present this bill or my colleagues in Southern Nevada. And with that, I would like to send the mic to, I believe, Jessica Adair is going to take lead on this
one. Good afternoon, Madam Chair and members of the committee. For the record, my name is Jessica Adair, and I'm the Chief of Staff in the Nevada Attorney General's office. I am joined here with many of the same colleagues you've already had the pleasure of seeing today. First Assistant Kyle George, Special Assistant Teresa Hart, of course, Attorney General Aaron Ford, and Second Assistant Christine Jones-Brady. And I'm happy to present the bill that I know you have all been waiting for, Senate Bill 62. SB 62 is a bill intended to increase transparency of organizations soliciting charitable contributions in Nevada and give the state additional tools to fight charity fraud. First, I would like to express our gratitude to Deputy Secretary of State Kim Parandi, Secretary of State Sagaski, and the entire Secretary of State's office. Their assistance in the formulation of this bill has been invaluable and undoubtedly improved the bill so it best serves the state and our mutual goals to promote transparency and trust. Before I begin discussing the text of the bill, I would like to give some background and describe the reasons our office sponsored this legislation. I can promise that this will be under 10 minutes. Charitable giving is one of the most important financial transactions of our society. U.S. donors in 2019 gave more than $449 billion to charity, billion with a B, with 69% of the funds coming directly from individuals, according to the National Philanthropic Trust. Charitable giving allows nonprofit organizations to serve important causes and those in need, and allows an individual to express their wishes, benevolence, and even their religious faith by supporting causes close to their hearts. Unfortunately, there are those who seek to exploit the generosity of others for their own greed. Charitable organizations registered with the IRS as a 501c3 organization must submit lengthy verification and documentation to demonstrate that the organization is organized and operated exclusively for charitable, religious, educational, scientific, literary, or other approved purposes, and must not be organized or operated for the benefit of private interests, and no part of the net earnings may inure to the benefit of any private shareholder or individual. Fraudulent organizations clearly cannot meet this threshold. So many turn to other kinds of entities that are easily formed and simply call it a charity. Common examples of these entities include PACs and LLCs. You are probably familiar with PACs, or political action committees. While most PACs serve a legitimate political purpose, there are those who use the more relaxed registration and reporting requirements to masquerade as a charity, solicit contributions from well-meaning people, and pocket those contributions for themselves. They often choose misleading names that sound like charities, or even use a slightly modified version of the name of an existing charity to take advantage of the public goodwill of the legitimate organizations. For example, the American Association of Police Officers Incorporated, Veteran Police Association Incorporated, Police Protective Fund Incorporated, and Junior Police Academy all sound like legitimate charities. These groups claim to assist local police and run educational programs. In reality, all of these organizations were run by the same individuals who were later sued for false statements in their solicitations and misuse of funds. Our office receives complaints regarding charity fraud, particularly after a disaster when people are very vulnerable. Yet these scam organizations can escape our jurisdiction and punishment. At the federal level, the IRS cannot revoke the tax-exempt status of an organization that never registered as a 501c3 in the first place. Under NRS 598.1305, the Office of the Attorney General has jurisdiction under this Deceptive Trade Practices Act to prosecute charities that make false claims in their solicitations. But this section only applies to organizations, quote, who the Secretary of the Treasury has determined to be tax exempt pursuant to the provisions of Section 501c3 of the Internal Revenue Code, end quote. If an organization is not a 501c3, the statute does not apply. This is the problem we are trying to solve with this bill. Scam charities do not serve the public, dupe well-meaning people out of their money, and put legitimate charities at a disadvantage. Turning to the bill, Section 1 of the bill expands the definition of a charity to include any organization that is or purports to be established for any benevolent, philanthropic, patriotic, educational, humane, scientific, public health, environmental conservation, civic, or other elementary purpose. I mispronounced that, but it was a new word that I learned thanks to LCB. Or the benefit of law enforcement, firefighting, or other public safety personnel, or in any manner that employs a charitable appeal as a basis of any solicitation, or an appeal that suggests that there is a charitable reason for the solicitation. The purpose of this bill is to require all charities, not just 501c3 organizations, to register with the Secretary of State. This information is then available to the public as a business entity, searchable on the Secretary's Silver Flume website. Charities are also required to file a very abbreviated annual financial report with the Secretary of State with basic information that would normally be included on a charity's 990 form with the IRS. Section 2 clarifies that a contribution does not include bona fide fees or membership dues. This is not intended to apply to clubs or hobby organizations. It also clarifies that a contribution does not have to be tax deductible. Donations to PACs, as you know, are not tax deductible. Sections 3 and 4 make conforming changes. Section 5 makes conforming changes to what an organization is required to report that reflects the types of organizations have expanded. Section 6 and 7 make conforming changes. Section 8 expands the jurisdiction of the Secretary of the State and the Attorney General to refer and prosecute violations of the DTPA or Deceptive Trade Practices Act for false statements when soliciting contributions to all charitable organizations, not just those who are registered 501c3s. And Section 9 makes conforming changes. And that concludes the presentation of this bill, and I look forward to answering your questions.
Thank you so much. I see Senator Pickard has a question. Go ahead.
Thank you, Chair Scheibel, and thank you for Ms. Adair for presenting the bill. I agree, this is something that has gone on too long probably as it is. I just have a couple of really brief questions. First, when you first mentioned the Secretary of State's office, I don't know that you said it, but am I to understand that they're on board with taking all this on, because registration of the number of organizations that we have is going to be pretty sizable, although they probably already take some. I know they take, for example, the reports from PACs. But do I understand correctly, they're on board with this to the extent that we're loading them up with more work?
Thank you, Senator. Jessica Adair for the record. Yes. The current process right now for charitable organizations is a very simple registration statement. It's one page. There's also an exemption statement that's one page to show that they don't have to register. And in our conversations with the Secretary of State's office, they indicated that it would be a very slight change to their current procedures, and they would be able to make that change without a significant financial or labor intensive impact to the office.
Senator Pickard, you're on mute.
Sorry, I probably put it on mute thinking I needed to take it off. Thank you. Thank you for that answer. The second question has to do with the new definition of contribution under Section 2. We're adding language that in my initial review suggests that we're actually narrowing the definition of contribution just to those that come in response to a solicitation. In other words, if someone goes out and solicits a contribution and then they get that contribution, that's a contribution. But if they don't overtly solicit it, then any money provided to that organization would not be deemed a contribution. Is that a correct interpretation?
Thank you, Senator. Jessica Adair for the record. Yes, that is the correct legislation, the correct reading of the bill that has been drafted. That's typically where we see contributions coming in, is in result of a solicitation, and even so much as a donate now, I think would be considered a solicitation. But I think you raise a really good point, and we could remove that from the draft of the bill to make that eminently clear.
I appreciate that. I always try to look beyond the intent of the bill and see where this thing could go. And I can just imagine saying, hey, I didn't ask for the contribution. It just showed up on my doorstep. So that's not a contribution. And now I don't even have to report it. And there is I think the rub, because many of these organizations are currently required to report to the Secretary of State. Anyway, thank you for your response. And thank you, Madam Chair.
And next, we will take a question or questions from Senator Hansen.
Thanks, Madam Chair. Real quick, over the years, I've seen some horror stories of supposedly legitimate charities, and they would have some investigative journalists would get a hold of their paperwork, and we find out that they'd have 80, 85, 90% of all the money donated being paid out in salaries and things like that, and virtually none of it going to what the charity was supposedly for. Is there some standard in state law or federal law or something that, I mean, at what point is that type of situation considered a violation of charity?
Thank you, Senator. Jessica Adair for the record. So if you're looking for an exact percentage, we don't have that in state law, but you're exactly right that those are the horror stories that we get as well in terms of the complaints that our office receives, and why it's so frustrating when those organizations escape our jurisdiction under the current law. However, even though there isn't a specific threshold, we do have a few tools. So for example, a false statement, 100% of your donation will go to these people in need. If that isn't true, that's a false statement, and we can use the Deceptive Trade Practices Act to then prosecute that. Another important point is if those organizations are 501c3s, by definition, none of those proceeds can inure to the benefit of the shareholders or of the nonprofit organization. So that would be a violation of the 501c3 requirements under the Internal Revenue Code, and they could have their tax exempt status revoked. But that DTPA hook is exactly what we're looking for in order to get at those who are very much just profiting from these charitable solicitations, making promises that they have no intention of keeping.
Good. Well, I hope you go after those types. It's a real disgraceful thing, and it also creates a distrust for legitimate types of charities as well. Thank you, Madam Chair.
Absolutely. Senator Settlemyer.
Thank you, Madam Chair. You were unmuting me as I was trying to unmute myself, so I apologize. So this is aimed at trying to get all individuals that are holding themselves out as a charity or as a nonprofit. So again, basically the 501c3s to register with the Secretary of State's office, which I think it's interesting that I'm being told that they're basically neutral on this and they feel they can do it with no fiscal note, which to me, there's a lot of work that has to be done to register these individuals. So again, I just want to get clear on the record that this is about registering individuals that are holding themselves out as a nonprofit. And then if I could have a follow-up question, Madam Chair. I'm sorry, Chair.
Thank you, Senator, for the question. Yes, you are correct. That is exactly the purpose of this bill. And I will defer to the Secretary of State, though in our conversations, I will say I think this is similar to most state agencies that typically testify in neutral on bills that they don't introduce. But I cannot thank Deputy Secretary Kim Parandi enough for her help with this bill. And that is, we have mutual goals that we're seeking to achieve here.
Appreciate that. And if I could follow up on a different part of it. So you're a charity and you're holding yourself out as a charity, then clearly you're going to have to register with the Secretary of State when this bill passes. But what about donations from that charity? You know, in other words, so a charity decides to give somebody $50,000 to open up a satellite or do something, then they use that money and basically embezzle it. Is there any requirement of the charity to then divulge when they give, like say, more than $10,000 or something of that nature? Because I've heard of many instances where that has occurred, and it seems terrible because then, unfortunately, you know, churches sometimes they don't want to get the courts involved. They just kind of figure a higher power will take care of the issue. But then people in the church find out later and then become discouraged, or situations like that. So I'm just curious, is there anything then that we could do to then require them to disclose who they donate to? I don't know. I guess that gets into, I don't know how to even phrase that, but that has been a concern of mine.
Thank you, Senator. Jessica Dare for the record. So I want to clarify that this bill does not apply to any religious institutions. Churches are treated differently under the state law, and that this bill would not apply to them. I will say that in terms of the financial that have to be disclosed, this bill does not intend to change any of the existing reporting requirements. Currently, charities either give the Secretary of State their 990 form, which they're already submitting to the IRS under their 501c3 status, or if they're not a 501c3, estimated total revenue, total expenses, revenue less expenses, total assets, total liabilities, and net assets or fund balances. So I think that at least would give the Secretary of State an idea of revenue versus expenses. And if this bill that is consistent with current law gives the Secretary of State the ability to investigate any fraud that they potentially see and then refer to our office. So there are additional conforming changes that include requiring if not their principal place of business, the address for the custodian of records, etc., that gives the Secretary of State more information to conduct an investigation if they think that there is fraud afoot. But it does not include any detailed reporting of, so-and-so gave us X amount of dollars or that type of things. We're not seeking to expand the existing reporting requirements or financial disclosures for charities with this particular bill.
Thank you for that clarification, and thank you, Chair, for the ability to ask that questions. Thank you.
All right, I don't see any other questions. Does anybody else have a question on this bill? Okay, then we will go to testimony in support of SB 62.
Thank you, Chair. To testify in support on SB 62, please press *9 now to take your place in the queue. Once again, to testify in support on SB 62, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to give support testimony.
All right. We will go to testimony in opposition.
Thank you. To testify in opposition on SB 62, please press *9 now to take your place in the queue. Once again, to testify in opposition on SB 62, please press *9 now to take your place in the queue. Chair, there are currently no callers to give opposition testimony.
Thank you. We will go to neutral testimony on SB 62.
Thank you, Chair. To testify in neutral on SB 62, please press *9 now to take your place in the queue. Once again, to testify in neutral on SB 62, please press *9 now to take your place in the queue. Caller with the last 3 digits 101. Please slowly state and spell your name for the record. You will have 2 minutes and may begin. Caller with the last 3 digits 101. Please press *6 to unmute yourself, then slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon, Chair Scheibel and members of the committee. My name is Kim Perondi, that's K-I-M-P-E-R-O-N-D-I, and I serve as Deputy Secretary of State for the Commercial Recordings Division. The Secretary of State's Commercial Recordings Division is a filing office for official records and is responsible for the processing and recording of organizational and amendatory documents of business entities pursuant to the laws of the state of Nevada under NRS Title VII. Legislation was originally crafted in 2013 requiring Nevada nonprofits under Chapter 82 to register with our office before soliciting charitable contributions. In 2015, these requirements were placed under Chapter 82A and expanded to include in-state and out-of-state organizations. Please note there are some exemptions listed in 82A.110. The existing filing requirements in Chapter 82A include the name of the organization, their jurisdiction, places of business, their purpose, names of their officers, directors, and executive personnel, and certain federal tax status and financial report information. There is no fee to file these documents, and these documents are recorded in our database and available to the public at no charge. Senate Bill 62 was brought to our attention by the Attorney General's office in its draft stage for review and comment. The proposed changes to 82A under this bill cause no deviations to our current filing processes, nor do we anticipate any fiscal impact to our office. The Secretary of State's office does not get involved with the policy end, such as the expanded definition of charitable organizations. Therefore, we are not aware of the effects this could have on them. It is possible the expanded definition may cause an increase in the number of filings for our office, as well as the number of inquiries and investigations. However, at this time, we don't anticipate that to be enormous or unmanageable. The Secretary of State's office is neutral on this bill. Thank you very much.
Thank you, caller. And Chair, with that, there are no more callers to give neutral testimony at this time.
All right, thank you so much for your help, Mr. Kyle. That concludes our hearing on SB 62. At this time, we will move on to public comment, and I will ask that the lines be opened up for public comment, and each caller shall be given 2 minutes to speak.
Thank you, Chair Scheibel. To give public comment, please press *9 now to take your place in the queue. Callers, if you are here to give public comment, please press *9 now to take your place in the queue. And Chair, the phone lines are open and working, and while we do have some callers here, it seems to be that they're only listening, as none have entered the queue at this time.
Okay, I'm going to wait just a couple of minutes to make sure that everybody heard the instructions. It was to press *9 if they wanted to make a public comment. Is that correct?
That is correct, yes. And once again, callers, if you are here to give public comment, please press *9 now to take your place in the queue. We are currently on public comment. Please press *9 now to take your place in the queue. And caller with the last 3 digits of 963, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, I've already spoken. My name is Yesenia Moya. I just wanted to ask a question. Will there be a reading of folks' public commentary that were sent in? I think that's what I heard at the beginning of the meeting, that there might be a few of folks that have been impacted read from the Nellis or comments that were made online. Is that going to happen? If not, I'd just like to again claim my support for the amendments to SB 50, as we don't need any more terrorism in our communities. Thank you.
Thank you, caller. Once again, we are currently on PC. If you would like to get, on public comment. If you would like to give public comment, please press *9 now to take your place in the queue. Caller with the last 3 digits of 556, please slowly state and spell your name for the record. You will have 2 minutes and maybe.
Anne Marie Grant, ANNEMARIE GRANT. I thought I'd give a little background, a little more about my brother, because I will be submitting comment throughout the legislature. My brother's name was Thomas Purdy. He was 38 years old. He had a mental health crisis. At the Peppermill Casino, where he was a guest, he literally asked security for help. Security called Reno police, who hogtied my brother for absolutely no reason. My brother didn't assault anybody. Every page of the manual of the device, the hobble rip restraint that they put him in, says never use to hogtie a human being. He was hogtied for 40 minutes. He was then brought up to the Washoe County Jail, still hogtied. He begged for his life, told them he couldn't breathe, told them he had previous major lung surgery, which he had a collapsed lung. And after being in a hog tie like a wild animal with his body compressed for 40 minutes, they then decided instead of cutting the device off of them, because they didn't know how to get it off because it had been applied so tightly to him, they put him face down, and 4 deputies got on my brother's back and asphyxiated him to death. The staff then came in, medical staff, and sat there snapping their fingers in my brother's face. And for 10 minutes, it was 10 minutes before Remza got there and initiated CPR. My brother was brain dead and dumped up at Renown Hospital for 2 days. The jail never even tried to contact any of his family. The hospital, thank God, was able to reach us because he was a guest in your state. I think my time may be up, so I'll end it there. Thank you.
Thank you, caller. Caller with the last 3 digits, 208. Please slowly state and spell your name for the record. You will have 2 minutes to give public comment and may begin. Once again, caller with the last 3 digits 208, please press *6 to unmute yourself, then slowly state and spell your name for the record. You will have 2 minutes to give public comment and may begin. And Chair, that caller is currently unresponsive. Shall I prompt them one more time?
Yes, please.
Thank you, Chair. Caller with the last 3 digits 208, please slowly state and spell your name for the record. You will have 2 minutes to give public comment. You may begin now. Caller with the last 3 digits 208, please press *6 to unmute yourself. You will have 2 minutes to give public comment and may begin. And Chair, that caller is still unresponsive.
All right, then we'll move on to the next caller. And if that person manages to make it back into the queue, maybe the technical issue will be resolved.
Thank you, Chair. If you have just joined us, callers, we are currently on public comment. To give public comment, please press *9 now to take your place in the queue. Once again, we are currently on public comment. If you would like to give public comment, please press *9 now to take your place in the queue. And Chair, while the phone lines are still currently open and working, and we do have a few callers, I do believe that they are just listening as no one has responded at this time.
All right, well, I certainly appreciate your help, Mr. Kyle. I will remind everybody again that any written comments that you submit to that email address that I gave you, and I'm going to give it to you again, will be received by every member of the committee and made a part of the official record. That email address is senjud@sen.state.nv.us. You can turn in those comments at or that testimony at any time. And with that, our meeting will be adjourned. I'm just going to ask BPS one more time to check and make sure nobody else has entered the queue to make a public comment.
Yes, thank you, Chair. Once again, we are currently on our last public comment section. If you would like to give public comment today, please press *9 now to take your place in the queue. Once again, we are currently on the final public comment section. If you'd like to give public comment, please press *9 now to take your place in the queue. And Chair, the phone lines are open and working, and we do have a few callers who are still unresponsive, so I believe they are just listening.
All right, well, we welcome listeners and participants at the Senate Judiciary Committee, and we appreciate everybody's participation today. And now that we have heard our bills and our public comments, we are adjourned until tomorrow at 1 p.m. Meeting adjourned.